interesting thing from Gault that specifically addresses your point is that, and I believe this court discussed this in Asbury v. Payne, when you determine that the child is entitled to due process and he's a party who's deserving of that due process, all the practical implications fade in importance. And Gault said that now 40 years ago. It's no different today. But the checklist requires, first, that the notice requirements have been complied with. And that's straight from Gault. There's a big problem in Ohio, and this court can solve this problem. And in this, the 40th anniversary of Gault, Ohio's children deserve nothing less. And I don't think that that's fair. I mean, certainly the rules require that this be fair, and due process requires it. The court still had to meet basic due process. What's important about 29 is 29 embodies due process and embodies a lot of the things that were brought out in Gault. Gault warned that departures from established principles of due process lead not to enlightened procedure, but to arbitrariness. I also want to address that, historically speaking, juvenile court has provided a shield and keeps juvenile adjudications buried in the graveyard of the forgotten past. More than 60 years ago, in Haley versus Ohio, the United States Supreme Court recognized that a child in an interrogation is an easy victim of the law. Before that time, the right to counsel was provided only for, quote, hearings and cases, and that was soon after Gault. So in Gault, the court considered whether to extend the Fifth Amendment right to against child self-incrimination. So Gault addressed this interrogation quite extensively, but the court in Gault in 1969 or 67 noted that even then evidence was accumulating that showed that confession doesn't aid rehabilitation, rather that the perception of fairness is what aids rehabilitation. This was from 1962, obviously before Gault, before Miranda.